Hi, my name is Andrea Falls, and this is my midterm case presentation of the Slender Man Stabbing case for forensic science in the legal system at Duquesne University. On May 31st, 2014, in Waukesha, Wisconsin, 12-year-old girls Anissa Wire, Morgan Geyser, and Peyton Bella Lutner went to a park to play. During a game of hide and seek, Miss Weir and Miss Geyser lured Miss Lutner out into a wooded area nearby. Then Miss Weir jumped on Miss Lutner and held her down while telling Miss Geyser to go crazy, go ballistic, and stab Miss Lutner. With a knife she had taken from her house that morning, Miss Geyser stabbed Miss Lutner 19 times. Immediately after the attack, Miss Geyser and Miss Weir told their friend they would go find help. Instead, they left her bleeding in the woods and sent off to find Slender Mansion and become one of Slender Man's proxies. Wait, what? Who is Slender Man? Who is Slender Man? Slender Man is a tall, faceless, fictional boogeyman which originated as a horror fiction creepypasta internet meme. He has become an internet icon and is often depicted as stalking or abducting people, especially children, across all types of fan fiction media. Both Miss Geyser and Miss Weir enjoyed scary ghost-type stories and were fascinated by Slender Man and all the stories surrounding him. Their fascination led to delusions of becoming worthy of him and becoming his proxies by killing their friend. Then they would be able to join him and live with him in Slender Mansion. Miss Lutner was able to crawl from the woods to a nearby road where a passing cyclist found the victim and called 911. Miss Lutner was taken to the hospital and spent almost a week recovering from 19 stab wounds to her arms, legs, and torso. One of these wounds missed a major artery near the victim's heart by just a millimeter. After searching for the girls for several hours, a Waukesha County Sheriff's deputy found Miss Weir and Miss Geyser walking along Interstate 94 in Waukesha. When he asked where they were going, they informed him they were on their way to Slender Mansion, an imaginary place the girls believed to exist in the Nicollet National Forest, some 300 miles away from where the girls were found. In Miss Weir's backpack, the officer found a knife with a 5-inch blade as well as granola bars and water they had packed for their journey. Miss Geyser and Miss Weir were taken to the police department for questioning. Police detectives interrogated Miss Weir and Miss Geyser separately. These interrogations were videotaped, and the video shows both girls receiving Miranda warnings and both girls waiving their rights. Since Miss Weir and Miss Geyser waived these rights, their parents were not allowed to be present for the interrogations. During their questioning, both girls willingly confessed to stabbing their friend. They told detectives they had been planning to kill Miss Lutner since December to win Slender Man's favor and become his proxies. Miss Geyser and Miss Weir were arrested for attempted murder. On June 2, 2014, a criminal complaint was filed and both girls appeared in Waukesha County Circuit Court, where they were charged as adults with attempted first-degree intentional homicide. Wisconsin law compels the prosecution of homicide or attempted homicide to try defendants older than 10 years old in adult court. Bail was set for each of the defendants as a $500,000 cash bond. The defendants were denied contact with each other as well as with the victim. Possession of weapons and internet access was prohibited. Ms. Geyser's defense attorney requested a competency hearing for his client, and the judge ordered an examination be done by the Wisconsin Forensic Unit. The prosecutor also asked for an examination of mental disease or defect. Dr. Casimir, a state forensic psychiatrist, diagnosed Ms. Geyser with early onset schizophrenia and oppositional defiant disorder. He explained that there is a genetic predisposition, as Miss Geyser's father also suffers with schizophrenia. He went on to say that schizophrenia is not usually dangerous. However, when your fixed delusion tells you to kill people, insight doesn't tell you to get treatment, and hence we're here. Miss Weir's attorney also requested a competency hearing for his client. Both defendants were found to be competent on December 18, 2014. Additionally, defense attorneys for both co-defendants filed motions of reverse waiver to move their clients to juvenile court. The 2-day preliminary hearing began on February 16, 2015, to determine if sufficient evidence exists to proceed to trial on the charge of attempted homicide. The burden of proof rests with the prosecution. However, the burden is a prima facie case, which is the lowest legal burden. The state showed actus reus, that is, this was a planned voluntary act by both defendants, and mens rea in that both Miss Geyser and Miss Weir purposely and knowingly engaged in the stabbing of the victim with the intention to kill her. Detectives who questioned the defendants after their arrest testified with regard to the interrogations in which the girls confessed to the stabbing and also admitted that they had been planning for months to kill their friend. The advanced practice forensic nurse testified that she spoke to the victim when she was brought to the hospital, and Miss Leutner told the nurse her friends had stabbed her. Miss Luke also collected fingernail scrapings and the victim's clothing as evidence. Witnesses for the defense testified with regard to the defendant's state of mind. On March 13, 2015, the court determined there was a prima facie case and both defendants were bound over for trial. On May 21, 2015, Weir's defense attorney filed a motion to dismiss the criminal complaint based on the underlying law that put Miss Weir's case in the adult court was unconstitutional based on the violation of the Eighth Amendment of cruel and unusual punishment. He went on to state that keeping her from the juvenile court system violates her rights to equal protection and due process. This motion was denied August 6, 2015. As previously noted, defense attorneys for both defendants filed a motion for a reverse waiver to move the case from the adult court to the juvenile court. On August 10, 2015, in an oral ruling, Judge Boren denied this motion. In his statement, he said he easily finds that this is a violent and premeditated personal offense. There was a conscious decision made at the time of the offense to let the victim die. This was an effort to kill someone, not just a mistake as in hitting someone too hard. A serious offense has to be dealt with on a serious basis. Therefore, the defendants will be retained in the adult jurisdiction. On August 21, 2015, both defendants appeared in court for their formal arraignment. Their respective defense attorneys continued to object to the adult jurisdiction as no written order had been received. When asked to enter their defendants' pleas, both attorneys stood mute. The court then entered a plea of not guilty on behalf of both defendants. Both the prosecution and the defense filed multiple pretrial motions. The motion to suppress the co-defendants' confessions, since they did not understand the Miranda warning, was denied. The motions to stay proceedings until the Court of Appeals ruled on jurisdiction was granted. However, the Court of Appeals upheld the court's decision to keep jurisdiction in the adult court. The motion for bail modification was granted, and both defendants were allowed internet access for the purpose of school, with the provision it must be monitored by school staff. Ms. Weir's attorney requested a veneer of potential jurors from another county, and Ms. Geiser's attorney requested a change of venue. Both motions were denied. The motion to sever the co-defendants' trials was granted, as was the motion for jury sequestration for the length of the trial. In December 2016, evidentiary hearings are held, and the defense teams introduce the element of defenses in their cases. The pleas of both defendants are changed from not guilty to not guilty by reason of mental disease or defect. Now, with the change to an affirmative defense, the burden of proof shifts from the prosecution to the defense. Experts are called to testify on both sides. In Ms. Weir's hearing, Dr. Van Rybroek testified for the state and stated that Ms. Weir could not stop herself at the moment it mattered most and helped Ms. Geiser stab the victim even though she knew it was wrong. Dr. Caldwell testified for the defense and stated that Ms. Weir suffers from persistent depressive disorder and schizotypy, a mental disorder in which there is a diminished ability to separate reality from fantasy. In Ms. Geiser's hearing, Dr. Casimir testified for the state and found Ms. Geiser to be at continued risk for harming others. When he asked Ms. Geiser what she would do if Slender Man asked her to break into someone's house and stab them, she replied that she would have to do it. Dr. Collins testified for the defense and stated that Geiser's unyielding belief in Slender Man led her to fear the creature would hurt her and her family if she didn't kill her friend. On August 21, 2017, Anissa Weir pled guilty to count 2, attempted second-degree intentional homicide as a party to a crime with use of a dangerous weapon. A trial date for September 11, 2017 was set where she will proceed to a jury trial to determine her mental status. Ms. Weir's trial began on September 11, 2017 and lasted for 5 days. On day 1, 16 jurors were selected. 12 would serve on the jury and 4 would serve as alternates. The jurors were given instructions and notified that they would be sequestered for the length of the trial after it began. On the second day, the trial began and the state gave its opening statements, which were followed by the opening statements of the defense. The state then called their witnesses to testify, and the defense cross-examined these witnesses. This continued for part of day 3, and then the state rested its case. The defense then began to call their witnesses, with the state cross-examining the witnesses. This continued into day 4, and then the defense rested its case. On day 5, the defense made its closing arguments, which were followed by the state's closing arguments. The jury were again given their instructions and then retired to deliberate. After almost 12 hours of deliberation, the jury returned with a verdict. The judge asked the jurors if at the time the crime was committed, did the defendant have a mental disease or defect. The answer was yes. Then Judge Boren asked the jury if, as a result of the mental disease or defect, did the defendant lack substantial capacity either to appreciate the wrongfulness of the conduct or to conform that conduct to the requirements of law. Again, they answered yes. The jurors were polled by the court, and 10 of the 12 jurors voted yes on each count. According to Wisconsin law, only 10 of 12 jurors are required to render a verdict on whether a criminal defendant was responsible for her actions due to a mental condition. On October 5, 2017, Morgan Geyser pled guilty to count 1, attempted first-degree intentional homicide as a party to a crime, and not guilty by reason of mental disease or defect. Anissa Weir received her sentence on December 21, 2017. The hearing began with the state asking for the maximum of 25 years in institutional care. The defense rebutted and asked for institutional care until Miss Weir is 25 years old. Judge Boren then committed Anissa Weir to the Department of Health Services for 25 years, commencing December 21, 2017, with 1,301 days of credit. He went on to say that a conditional release would pose a significant risk of bodily injury to the defendant or others. Miss Weir was placed in institutional care and is required to take medications. Morgan Geyser was sentenced February 1, 2018. The hearing began with Dr. Brooke Lundbohm reading a victim impact statement written by the victim's mother. Judge Boren committed Morgan Geyser to the Department of Health Services for 40 years, commencing February 1, 2018. As in Miss Weir's sentencing, he stated that a conditional release would pose a significant risk of bodily injury to the defendant or others. Miss Geyser was placed in institutional care and is required to take medications. Peyton Bella Lutner returned to school in the fall of 2014, but the physical and emotional scars remain. She has extensive scarring from the 19 stab wounds as well as from the surgeries required to save her life. Miss Lutner still has deep fears and insecurities, but is satisfied with the final resolution, as she did not have to testify about the attack, and she still feels safe because both of the girls who attacked her are in a secure hospital. This concludes my presentation of the Slender Man Stabbing case. I appreciate any comments. Thank you.